Hey out there, legal warriors. Do you need proof to get a restraining order against somebody? I get so many calls that says, but there's no proof. You will be surprised about my answer. Stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm has been defending people charged with crimes all throughout Washington state for more than 20 years. I'm putting out these videos to educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now, I just said my law firm defends people charged with crimes, but we also defend people that get served with a restraining order. We also try to get restraining orders for people, and that's not totally unusual for criminal attorneys. Basically, two main types of attorneys, in my opinion, do restraining order cases: criminal attorneys and some family law attorneys. And Washington state actually calls them protection orders under RCW 7.105. But when the public thinks about them, they usually think of a restraining order. So what is a restraining order? Restraining order is between two individuals, not between the government and an individual. Like if someone is charged with a crime, then basically it's the state of Washington versus defendant, or city of Lynnwood versus defendant, or city of Seattle. You get it, versus defendant. In a protection order case / restraining order, basically an individual goes into a court and petitions for restraints to be placed against someone for doing something that the petitioner, the person asking for the relief, says is wrong. There's the domestic violence protection orders, anti-harassment protection orders. That's like, they're annoying you or threatening you, think neighbors, stuff like that, when you don't have a family or dating relationship, like in a domestic violence restraining order. Stalking protection orders, sexual assault protection orders, those are vulnerable adult protection orders, all these types of things. And what I often hear is a respondent comes in and sends us in their stuff they got from the court restraining them. They get the petition from the petitioner that alleges a bunch of stuff against them. And what do they say? What do they say on the phone? But there's no proof. How could they do this to me? There's no proof. And it's sad to know that proof is whatever a judge says it is, right? Well, the petitioner claims that I have been harassing her and threatening her or texting her bad things, or that I was, that I pushed her at some point, or I pushed him at some point. But there's no proof of that. How could they get this order? Well, all the judge does in these hearings is they take a look at the petition and they read it and they go, hey, does that sound like it could have possibly happened? And if it sort of sounds like it could have possibly happened, it seems that it's in the realm of human existence. There's very little incentive on a judge to deny the petitioner their protection order, because the burden of proof is a preponderance of the evidence, which means is it more likely than not that whatever the petitioner claims happened that would give them a right to a protection order, is it more likely than not that that happened? And how can a judge ever know except just sort of doing the sniff test? The statute doesn't require proof. What I often tell people calling on the phone is like, hey, their proof is their claim it happened. Now, that sounds like total lunacy, but it really is how it works in Washington court in these hearings. I think the legislature made a big mistake when they passed RCW 7.105 effective July of 2022, in thinking that the court would somehow hold the line on proof. And the court just doesn't have time for that for most courts. I mean, imagine they've got an hour-long calendar. They got 15 of these cases on, and they're all types of jumbled gobbledygook, and people are talking about things that don't matter and things that do matter. There's not a lot of mental energy available, and not a lot of incentive for a court to deny someone relief when they're acting scared, when they're acting harassed, those types of things. So it's very much subject to abuse. So proof, in the way that we think of proof out there in the public, do you have a text message? Do you have a photo? Do you have a witness statement? Is that required under the statute? Absolutely not. So what do we do about it? What do we do about it if we're a respondent and we're trying to fight this? Well, what we do is we try to make the person making the claims look like they're not telling the truth, because oftentimes they're not. How can we show that their claim is ridiculous? How can we show that they're the aggressor? Do we have text messages where they're the aggressor? Do we have photos of our injuries? Can we get witness statements, right, from people that say differently? Can we show what their motivation is to make something up and just claim something? But we really have to go at them with napalm. We have to throw the kitchen sink. We have to not be nice and kind, typically, when we defend these, because we have to convince the decider, there's the judge, there's something in it for them. Be brave to say that, hey, petitioner, you haven't met your burden of proof. Because, again, proof is whatever the judge or commissioner says it is. And it's very, very low. We take a look at the definition of domestic violence for a DV protection order. It got expanded to a huge degree. Violence isn't even necessary, right? Subjective fear of the petitioner can be enough. A claim that somebody is under coercive control, that at some point in the relationship, perhaps you thought the petitioner was cheating and you might have said something along the lines of, hey, where are you going tonight? Let me see your phone. That falls under the statute as domestic violence, keeping tabs on someone, something like that. So it's very broad. And also in the statute, there's really no limit on the look back period. It doesn't matter if it's old or it was 5 years ago or 8 years ago. It only matters if a commissioner or a judge decides to make it matter. And they're sort of encouraged to not care about time. It doesn't say in the statute that, hey, if it's old, it doesn't count. And again, all incentive is on the judge or the commissioner to grant the relief. It takes no courage to grant the relief. It takes a lot of courage to deny the relief. And I think it's pretty understandable that given every person in the system is self-interested, it's hard to find judges and commissioners that are more likely to deny an order than grant an order. Because the legislature's made it clear they want to make it easy to get orders. It's a very low standard. Evidence rules don't apply. So if you get served with one of these orders, it's important that you put up a vigorous and strong defense. You need to get an attorney, and you need to also be careful what you say. You don't want to admit to crimes. You don't want to admit to things in your response. Everything you say there can be used against you. And you really need to read the statute, RCW 7.105, see what it is the petitioner has to claim. Look at every claim in the petition to see what was claimed, and you need to answer all of those in writing, okay? But the purpose of this video isn't to tell you how to do that. I've got other videos on the station. The purpose of the video is to have you to sort of dispel the notion that because there's no proof, I'm going to win. That's what everyone thinks, and that is not how it works. Proof is the claim. The claim of the petitioner in this situation is proof enough. I may get destroyed in the comments, all the people who think they know stuff, and how it should be. I don't deal with how it should be. I deal with how it is, and I want you to know how it is. So these are winnable. We win plenty of them, but it takes a lot of work, and it takes a lot of effort, and it takes a story that we can paint that shows that the petitioner is a liar. That's what we have to do in these cases. So I hope you found this video useful. If so, please like and please subscribe. More people get the help they need. More importantly, if you got served with an order or you need to get an order against someone in Washington State, feel free to give my office a call. We'll listen to what happened. We'll identify a way forward. And we will be there for you. Thank you.